This is the Mildred Gaddis Show.
It's 4:35 in the Motor City. I'm Mildred Gaddis. My next guest has been honored as one of the best lawyers in America, the oldest and most respected peer-reviewed publication in the legal profession. Attorney Gerald Thurswell is a highly regarded expert in medical malpractice, birth injury, as well as auto accident litigation. He has obtained numerous multi-million-dollar jury verdicts and settlements for injured people in courts throughout Michigan, as well as some other states. And I also need to share with you that he successfully won a settlement in the Renisha McBride case most recently. But today, he's going to talk with us about some movements in the state legislature you really, really, really need to be aware of. Good afternoon, Attorney Thurswell.
How are you today?
I'm good. Good to talk with you. It's been too long. That's my fault, though. It's been too long. Counselor, what's happening here with what's going on in the legislature as it relates to birth injuries?
Well, let me tell you what happened. Last Tuesday, about 8 or 9 days ago, we took a case up to the Michigan Court of Appeals. A woman was pregnant, and as a result of medical malpractice, her baby that was 18 weeks gestation died. And it was clear malpractice. The doctor that we were suing had been sued 29 times before. So the law up until last Tuesday was if a baby died before 24 weeks pregnant, gestation, there was no case. If you were in a car accident and the woman was pregnant and the baby was less than 24 weeks, you could not sue for the loss of the baby because the baby was not considered viable, capable of living outside of the mother's uterus. This was a medical malpractice case that we took to the Court of Appeals, and because it was clear malpractice, because the doctor had committed malpractice 29 times before, we thought this was the perfect case for the Court of Appeals to change the law. As a result of our case last Tuesday, the law in Michigan is now changed. If, God forbid, as a result of a doctor's malpractice, a baby that is not capable of living outside of the mother's uterus, a baby who is less than 24 weeks gestation, dies as a result of medical malpractice, you can now sue the doctor and collect compensation. Similarly, if you're involved in a motor vehicle accident and you're pregnant and the baby you're carrying is less than 24 weeks, you are permitted now to sue for the loss of your baby. This was never the law before last Tuesday. There are only 7 other states that permit this. Michigan will now be the 8th state that permits a lawsuit against someone whose negligence, whose malpractice causes the loss of a non-viable baby.
It's refreshing. That's exciting.
It's very, very exciting because the court stated in its opinion, it said, why should there be a difference if the baby's 24 weeks and capable of living outside of the mother's uterus, or the baby is 7 weeks or 10 weeks, or as in our case, 18 weeks. The court said there really should be no difference, that when someone loses a baby, whether it's viable or not as a result of somebody else's negligence, the family should be able to sue for the loss of that baby. This is a historic decision, and it was the right case we thought to take to the Court of Appeal.
You know what? Congratulations, and this is so important. I'm wondering, oh my goodness, in the past, the fact that there was no relief or remedy for a woman who lost her child due to negligence. I hope people realize just how huge this is.
It is, and what had happened in so many states is they tried to analogize this to a woman's right to choose, a woman's right to have an abortion, because a woman can choose to have an abortion up until 24 weeks, up until viability. Because according to Roe versus Wade, once a woman reaches 24 weeks and a baby is viable, then she can't have an abortion. It's considered to be a person. And this distinction between that type of case in our case, there is a clear distinction. The mother has a right to choose up until 24 weeks whether or not she wants to have an abortion. Similarly, the mother who is pregnant and wants to have her baby and wants to continue with the pregnancy, if the doctor's negligence causes the death of that baby, or if a motorist drives his car negligently and causes the death of that baby, now the mother can sue. So women will still be allowed to have abortions if that's their choice. And similarly, if somebody's negligence takes away their baby before the baby's viable, the mother still can seek compensation.
Attorney Thurswell, I am sure that based on life experiences, that there are a lot of women out there, if something happens to their baby due to negligence, some of them will pain in their hearts, emotionally aching for a while, and not realize that they have some options to seek some relief.
Well, especially in these cases involving premature babies, so often the doctor will say, well, you had a miscarriage. We don't know the cause. It's just a miscarriage. There's nothing you can do in the cases of these premature babies. However, depending on the situation, the facts in the particular case, there are women who have a miscarriage because they have what is known as cervical insufficiency, cervical incompetence, where if the doctor's examinations by ultrasound and other testing determine that her cervix may open prematurely and the baby just may fall out, if this is such a woman, they can put a stitch in and keep the cervix closed. Similarly, there's medications now, in the last 3 or 4 years, there's medications called progesterone, where they can start giving the mother either vaginal suppositories or shots, which can prevent a premature birth, can cause a baby to go to term, go to 39 weeks, 36 weeks. So the mother doesn't have to suffer a loss either before it's viable at 24 weeks or have a baby born at 25 weeks or 27 weeks. Because these babies that are born prematurely, there's a high risk that those children will have developmental delays and or cerebral palsy. And so often the mother is just so happy that she delivered a live baby and the baby's alive, she doesn't realize this baby should not have developmental delays. This baby should not have cerebral palsy. And if the doctors had treated the mother appropriately prenatally by either putting in a stitch, stopping the cervix from opening, or giving this medication, progesterone, these babies could go to term. And these babies don't have to be born prematurely. And we've been very successful in winning cases like that, where a stitch is put in to keep the cervix closed, or the mother's given this progesterone.
This is historic and really, really exciting news. And I think, we've just got to find a way to let the women know that they're, you know what I mean?
Because they walk around and they say, oh, I had a miscarriage. Oh, I had a miscarriage. A lot of times those miscarriages can be prevented. Many, many times those premature births resulting in a baby having cerebral palsy or developmental delays, those kids could have been born at term and not suffered the lifelong consequences of having either cerebral palsy or developmental delays, mental disabilities, cognitive deficits, etc.
Let me ask you a question, Attorney Thurswell. If a woman feels that she has been injured through her physician, that the result of her not being able to bring a child to term, let's say she picks up the phone and she gives you a call. What we
do is we get the medical records.
That's what I want to know.
We do several things, and we probably do as many birth injury cases as any other law firm in Michigan. There's very few of us that do a lot of, and we do a tremendous amount of birth injury cases. So mother calls and she's got a child that has a disability, whether the child is cognitively delayed, has mental retardation or cerebral palsy or developmental delays. What we do is we get the prenatal records. We examine the prenatal records to see if something could have been done so that the pregnancy could have gone to term, if treatment could have been different. We get the labor and delivery records to see if the doctors delivered the baby soon enough by C-section or vaginally. We checked to see how the baby was resuscitated immediately following the birth. Was the resuscitation proper and timely? And then we look at the baby's course in the nursery, or in most of these cases, in the NICU, the neonatal intensive care unit, to see if the care and treatment that the baby received in the nursery was proper. So we examined every piece of medical care that was given to the mother and to the baby to see if different care would have changed the outcome. And then if different care would have changed the outcome, was it malpractice? Was it professional negligence that resulted in this adverse outcome of cerebral palsy, mental retardation, developmental delays? So we're very, very thorough. And in addition to us doing this, we have a nurse that works in our office who works in labor and delivery. She examines the records. We put together a letter. We send it out to different experts. They have all these areas that we've looked at, evaluated. And it's very tragic where so many people just say, well, this was just God's will. This is what happened. Many times it wasn't God's will. It was a doctor or nurse's negligence that resulted in these horrible injuries, lifelong permanent injuries. And when we're able to be successful in these cases, we make a difference in these people's lives. We make a difference in the child's life. We make a difference in the parent's life because these children require lifelong care by the parents or by others.
In a case brought before the State Court of Appeals on June 16th by the Thurswell Law Firm, the Court of Appeals, in a unanimous decision, this is really interesting, a unanimous decision ruled that there was no sound legal basis in Michigan for treating the wrongful death caused by medical malpractice to a non-viable baby any differently than the wrongful death of a viable baby as a result of medical malpractice, therefore making Michigan the 8th state in the country to stand on this particular law, which is huge. It is really, really huge. When we come back, we're talking with Attorney Gerald Thurswell. We're going to give you the number to Attorney Thurswell, and we'll have a few more questions for him. So if you have a question or a comment, give us a call here. Give him a call here at 568-1200. I'm Mildred Gaddis.
Compelling talk you can count on. This is the Mildred Gaddis Show on News Talk AM 1200 and 99.9 FM WCHB.
Motor City here on the Mildred Gaddis Show. Attorney Gerald Thurswell of the Thurswell Law Firm joining me. We're talking about this historic ruling by the state state appeals court rendered in a case presented to the court by Attorney Thurswell's law firm. This is really, really huge. On June 16th, the State Court of Appeals ruled that there was no sound legal basis for treating the wrongful death caused by medical malpractice to a non-viable baby that depends on the time the baby has been in the womb, than any differently than the wrongful death of a viable baby as a result of medical malpractice. Attorney Thurswell, and this might not be a fair question, how often has this kind of thing been happening?
Oh, my God, it happens all the time. All the time it happens. We get calls. We probably get 100 calls a week on medical malpractice cases. My office does. And it's so sad when we turn down cases and the mother would present a story to us, so clear malpractice, so clear the malpractice was committed. And we have to tell the mother, we can't sue on behalf of your child. We cannot do it. That's the law. This particular case, the malpractice was so gross, and the doctor had been sued 29 times before. We just said, we have to take this case up to the Court of Appeals. We have to change the law. And thank God we were able to do that. But this is not only applicable now in medical malpractice cases. This is going to apply to those cases where a woman gets in a car accident and all of a sudden the baby comes out and she has a miscarriage. Those women, before this case was decided, could never sue for the loss of that baby. So if you're in a car accident and this happens, if you're in a slip and fall accident and you fall and then they rush you to the hospital, you deliver a baby at 20 weeks or 22 weeks, you can now sue for the loss of your baby. Whereas before last Tuesday, you could not in Michigan. So it's huge. It's across the board. People who are negligent and cause the death of a baby, whether it's viable or not, are now responsible for their acts. They're now responsible to provide compensation to that family who lost their baby.
You know what? I want to shift gears here for a minute because this is incredible. You were able to secure a $3.54 million judgment in a case for the misdiagnosis of breast cancer?
That wasn't our case. That wasn't.
Okay, I'm sorry. On this website, it had listed there. Well, the Huffington Post did list that your law firm successfully obtained $10 million.
That happens all the time. We had a case, kid had cerebral palsy. We had, I think it was $11,500,000. Just in the past year, a child had what's called Erb's palsy or brachial plexus injury. Child was delivered, and they put excessive traction on the baby's head when they were delivering the baby, and the baby's shoulder got caught. And we had a $9.4 million verdict within the last, 4 or 5 months. The only way doctors and hospitals are going to be responsible and be more careful is if they're held accountable. And the only way really to make them to be held accountable is when it has to come out of somebody's pocketbook, when they have to pay for it.
Now, is there, and this is something I think that happens too often, and that is the people's delay in trying to, in deciding to come forward. If you have a doubt, is there a problem with waiting too long to, no matter what kind of legal issue it is? You know, lay people tend to...
Depending on the case. If it's a baby that's alive, the baby's alive, and the baby has suffered an injury at birth, they have to sue before the child is 10 years of age. On the other hand, if the baby dies, you have to sue. It's sort of confusing. You have to sue within 5 years from the date the probate court opens up an estate, or 2 years from the date the probate court opens up an estate. So, in most cases, you have almost 5 years if it's the death of a baby, and if it's a baby that's living, you have up until the child reaches the age of 10 to sue.
Incredible. I want to give our listeners the number to the Thurswell Law Firm. It's 866-354-5544. That's 1-866-354-5544. If a person is in doubt, because we lay folk, some of us are so intimidated by the process when it comes to legal matters simply because we don't know. We just don't know. If they don't really know, they should call, yes?
Absolutely, because when a doctor commits malpractice, they don't come to the patient and they say, you know what, we were careless, we were negligent, and this has resulted in your injury. And it's in all the malpractice cases that our office handles. Doctors don't come forward and admit that they were negligent in the care and treatment. They don't do it. It just doesn't happen. But if people, and you know what happens also, Mildred, which is very interesting, people will call me on the phone with a possible case, and they start off the conversation and they say, I'm not that kind of person. Well, I don't know what that means when they say that, because if your car is on the street and somebody smashes into your car and causes damage to your car, you have no problem whatsoever asking that person, compensate me for the damage to my car. Nobody has a problem doing that.
Right.
And the most valuable thing that we have in our lives is our health. And when the doctor's negligence takes away our well-being, that's when you should really speak up. have this thing investigated, whether it's my law firm or another law firm. You should have this case investigated if you think somebody's negligence has caused you an injury or the death or disability of a loved one.
All right, Attorney Thurswell, this is again, congratulations. I mean, you guys have made history and really changed the quality of life for a lot of people in the state. Once again, if you'd like to reach Attorney Gerald Thurswell, the number is 1-866-354-5544. That's 1-866-354-5544. And the good news is that they've been around for a long time. And that's always important. Thank you, Counselor. Really, really appreciate you talking with us here today on this Monday.
Have a great day, Mildred.
You too.
Talk to you soon.
Okay, bye-bye.
Take care. Bye-bye.